My name's Christine Ramalona from the wealth management firm EXS Capital, filling in today for Jessica Cutrera and the Law Committee. So thank you for joining us. Happy belated Thanksgiving for everyone. And welcome to our members and welcome to our non-members. If you look around the room and you see anyone with a red, yellow, or blue badge, those are a few of our members. And for any of our non-members, we'd love to see you at more events and have you join us. So I'm sure you could speak to any of our current members about the benefits of joining and how to do so. With that in mind, if I could ask you just to silence your cell phones or any other devices you have, I can introduce our wonderful speakers for today. Alfred is a partner in the Dispute Resolution Group at OLN and has been a partner since 2007. He has carved out a niche for himself in that he is now one of the most highly respected contentious probate lawyers in Hong Kong. He is recommended as such in this year's Chambers and Partners. He is therefore best placed to talk about the pitfalls he comes across as a result of bad drafting in testamentary documents and in his vast experience as a practitioner in family disputes. Scherzade is a registered foreign lawyer in the private client group at OLN. Her practice focuses on the needs of the individual, often high net worth individuals, and she regularly advises on complex cross-border wealth planning and general commercial matters. She came to OLN from the UK about 3 years ago, having trained predominantly in family law. She uses that experience when handling wealth planning matters, and in particular is passionate about advising families on how to protect themselves and their wealth. Scherzade and Alfred have been working closely together to build up OLN's award-winning private client practice group, and they also collaborate on various legal publications such as the LexisNexis Hong Kong Encyclopedia of Wills and Precedents, LexisNexis Practical Guide for Wills and Probate, and for Hong Kong Lawyer Magazine. So I'll pass the mic over to Scherzade. Alfred.
Thank you so much, Christine. Okay. I would like to just start with a little bit of history for you, business history, rather than the law. We all love history. I have a little saying for you, and see if you know who this is. I'd be so impressed if you do. The banker's calling is hereditary. The credit of the bank descends from father to son. This inherited wealth brings inherited refinement. Sound familiar at all? That was the editor of The Economist back in the 19th century. He was talking about the way in which business enterprises was novel for patriarchs, and I deliberately say patriarchs, not including matriarchs, because it was the case at that time, as a new method of transmitting their wealth, and equally important to them, their status in the hierarchy to future generations. It got me thinking when I was reading Mr. Badgett, who was the editor-in-chief at the time. When I was reading about him, it got me thinking about the adage that you shouldn't work with family, that's no good business. This obviously doesn't sit very well, either in Hong Kong or the rest of the world, because if you simply look at any of the statistics which are widely available, you quickly see that family businesses make up 90%, that's 90% of the world's companies. So looking back in time, it's certainly fair to say that some of the predictions that were made by the gurus of the time, by the business historians, that they didn't get it quite right. Many of those business historians made predictions that family businesses would become defunct due to public companies. And they said that was because those public companies went out looking for more capital and potentially for more talent to succeed those companies. It was thought that family businesses would simply be thrown to the periphery, to the margins of the markets, because they wouldn't be able to compete with the public companies in terms of talent and capital. I think that the point on talent is really interesting, and I will come back to that later. But in short, the family businesses across the world, but particularly in Hong Kong, as you all know, are thriving. What we originally intended to do with this presentation was actually give business owners themselves a bit of an insight into the kinds of conversations they might need to be having about their succession planning. But I think it's really interesting that that we basically had to retailer our presentation, because you are all people that are on the advisory side. I think I'm right in saying, all of you, you're not the business owners yourselves, which is really interesting, I think, because it shows how little the business owners, they either appreciate the need to know about these things, or the interest, or the time, that they don't have the time to invest in it. But one of the things that I hope you'll take away in terms of being on the advisory side is great. One of the things I hope you'll take away was the issues that you can raise with those types of people. So we basically tailored the presentation. We had to rejig it a bit in light of the business owners themselves not being here. So just to give you another interesting statistic, which you may well know, the top 15 families in Hong Kong control assets worth about 84% of the region's GDP. I just thought that's pretty astonishing. And especially in light of the fact that the business owners themselves really do spend very little time thinking about succession. Good planning and open discussions, I'm probably preaching to the choir here, those things are essential for family businesses. And considering putting in place a family constitution and family governance will certainly come into play. So before I go on to that, I will just let you know what we have got to talk to you about today. So what we will be covering, the sorts of issues, as I said, the sorts of issues that you may wish to speak to the owners of businesses about in the course of your daily work. What they can do, what they should do, but what they can do in terms of meeting their business succession objectives. And then in order to decide what they can actually do, you need to know what kind of structure they're using. So then we'll cover some of the common business structures in Hong Kong, namely sole proprietorship, limited liability companies and partnership, and how to ensure the continuity of those common business structures. So some of the issues that you may want to discuss with family business owners. I think you will all appreciate that relationships are extremely important when you're talking to your clients. You need to build up that kind of relationship with them that enables you to have some of the difficult conversations that you may need to have. First of all, you're probably going to quite easily establish who the patriarch or matriarch is. So this is the key decision maker, and that is the person that first and foremost you're going to formulate the bond with. One of the things that they really should be doing, which often doesn't get done, is bringing into the conversation, into the dialogue at an early stage, the younger generation, the people that they're actually considering in terms of their business succession planning. According to a very recent survey, the most highly valued attribute of Asian family businessmen, can you hazard a guess what that would be, the most highly valued attribute in terms of leading the business? Can you think what that would be, considering a patriarch, usually an older generation? Any ideas? Okay, I would have thought, and if you're thinking this, tradition's extremely important in Hong Kong to older generations, to the Chinese. So it was very, very surprising to me to read that the number one attribute was leading innovation and change. But from our experience in terms of, our day-to-day work at OLN, we see that tradition is very important. And I started to think about, well, how do those two things sit together, really? I think they are a juxtaposition of each other, and that's quite a difficult thing. So considering those kinds of dynamics, that will be essential when you're talking to the client about who they're thinking of handing over the reins to, who they're thinking of handing over the reins of the business, but also their wealth that goes with it. One of the things that I think a lot of business people may forget about sometimes is the soft skills, the interpersonal skills, the people management, how they're going to keep the employees together. But in terms of family business, most importantly, how are they going to minimize the risk of dispute within the family? How are they going to manage the family dynamics? How are they going to keep the family together? So you see that these kinds of conversations, they're difficult conversations to have. And that brings me back to my point about your relationship with the client and building up that trust early on and bringing in the younger generation early on as well. What we aim to do, and this is something that Alfred deals with a lot as a contentious practitioner, it's avoiding ruptures. And that's really one of the key things that we want to try to avoid, is ruptures within the family that can disturb the intention of the business owner in passing on their wealth and the business. So the issues that really apply to when it's not a family business, it's very similar stuff. So who's the key decision maker? Do they have a second in command already? Bring them in at an early stage, find out more about that person and what the objectives are. Think about any employment contracts there are, any employees that need to be taken care of, and we will come on to what you can do, what the kind of advice you can give as to how to look after employees a bit later on. So, the things that a family business owner should and can do. Something that's quite novel in this area in Hong Kong, I think, is putting in place a family constitution. Family businesses can be very hard to define, so having constitution and bringing advice to the client about family governance is something that would be very, very useful to clients. It's just simply, it doesn't seem to be on their radar. By family governance, just to be clear, what we're really talking about is the way that the family members are interacting and how family wealth is going to be passed down. So then consider some of the following: the family dynamics. I already said the wealth being passed down. Board composition. I wrote down board size, but later I was thinking, actually, it's board composition as well. Because if you've got, you may have, as the patriarch, again, I'm specifically choosing the male gender, you may have very, very deliberate ideas about board composition, not just the size of it, but what about the female family members? I think traditionally, was always men on boards, which is why my quote from the editor refers to the patriarch and to sons being passed wealth. Well, what about now? With daughters who are equally well educated, equally capable, maybe more capable, how are they then going to deal with potentially a son who might create ruptures in the family because of a daughter being chosen over them? All of these things are very, very difficult conversations to have, but essential in terms of minimizing conflicts so that you don't have to come to Alfred for advice about the conflict, because that's what he does. Family philanthropy I will touch on a little bit later, actually. And again, for just a business owner, for not necessarily specific to family, so the same principles generally apply. Thinking about board composition, how to resolve conflicts, putting in place an exit strategy, and management of employees. But what's essential is for your clients to understand the vehicle that they have which takes us on to the common business structures. So I'm going to just finish off with sole proprietorship, and then Alfred is going to talk about the other two common business structures after that. So sole proprietorship really is the most basic form of business structure. A lot of the clients, well, the executors who act for a client, if indeed they have a will, they often don't understand that the business assets in a sole proprietorship are actually personal assets as well. But most importantly is the personal liability. The owner bears all of the liability in the sole proprietorship. So I'm going to give you an example of Tom. Tom is a sole proprietor. He has 2 employees. He has 2 million accounts receivables and $1 million of book debts. Tom, of course, is married and has 2 children, so he has dependents. His wife doesn't work, which is it's very, very important that if you're talking to clients that you find out those kinds of things. He's the only breadwinner, so immediately alarm bells are ringing. How is she going to manage? How is she going to support herself and the children? So what happens if Tom suddenly passes away? And what can he do during his lifetime to minimize the difficulties for his wife? So when he passes away, I'm sure you probably all know this already, all bank accounts are frozen. Because his business account is a personal asset, it also is frozen. A lot of our clients, they don't realize that that's going to happen, which means who's going to pay any of the expenses, the debts that we referred to, the salaries of the 2 staff that he has? Who's actually going to run the business? So it's obviously it's a functioning business. He has 2 staff. Who's going to be the decision maker? We don't know in this scenario if there is one. Who can provide for his dependents? Who's going to recover any of the money that's owed to him? Who's going to take care of his tax return? So, first of all, we can't give the advice, the financial advice, but we would suggest speaking to the right people. We have the right contacts to suggest taking out key man insurance. What you want to have is sufficient coverage for all of the potential liabilities, so you can take care of that all-important tax return, for example. Making sure that you've got also put in place the cover for your dependents as well in that situation. What we really want him to do, and this is what Alfred and I deal with, not the insurance side, but the making of a simple will can minimize so much of the trouble that would be left to the wife if there isn't one. In terms of the actual business, what he can do, I've said, is leave instructions in any format really, but we as lawyers, we usually do a letter of wishes for our clients. You can put any of the details that you want in there as to how to run the business, what assets you've got, what needs to be dealt with in what way. And aside from that, although this seminar wasn't focused on the private individual, but in terms of looking after his wife and children, he can also put his wishes in there about them specifically as well, so about his personal side of things as well. So, with pleasure, I'm going to hand over to Alfred. Yep.
We've just covered the sole proprietorship situation. There's one thing that I want to emphasize in relation to the advice the suggestion that we are giving today, in relation to the 2. The main reason why we are suggesting a key man insurance policy is the efficiency of payment. Think about it. When the only person who has access to the business bank account, who is often used to also cover the family expenses. When that person passed away, nobody else will have access to the particular bank's account. Who is going to cover all these, from the electrical bills to the school fees to, as we just said, the salaries of the employees? And this is why it is very important for the beneficiary, that is especially the wife, to have a bit of cash in the hand as soon as the person passed away. That would provide immediate relief to the family. At least she doesn't have to worry about what is going to happen in the near future. To give you a very good example, probate process. Even if the client has made a very simple will, leaving everything to his wife, the probate process itself would take at least 2 months. And who is during that 2 months, who is going to cover all these expenses, immediate needs? And if the particular person did not make a will, and we see that very often when that particular person is facing a sudden death, who is very often when a person is still running a fair operating business and he suddenly passed away due to accident or a hidden disease. This sudden death caught everyone off guard. And when it's off guard, everyone panics. And with that particular policy paying out a certain sum, that would provide a very strong immediate relief to the family and to the business. And later on, if the probate is at hand, if anyone is interested in acquiring the business, such as the staff that has been working for him in the company, the widow can also consider selling the business to him at a particular price, and the business will continue, everyone will benefit, and at least the major legacy of the family wealth can pass on to the next generation or to the staff. So this is covering the sole proprietorship situation when the business is usually quite simple and the turnover is not particularly high, like what we just said, 2 million. The reason why we say 2 million is that 2 million benchmark is the mark that the IRD, Inland Revenue Department, requires an audited report for every year tax return. So when the turnover is less than 2 million, usually the IRD would not require an audited report. But when the business is over that amount, audited report would be necessary. And as we just say, sole proprietorship, the major disadvantage is that the business risk, that is the liabilities, is also the proprietor's personal liability. And most of the people are properly advised would consider how to ring-fence this liability. And this is why a limited liability company comes into place. In the past, like 10 years ago, we have this company's ordinance which requires at least 2 members in the limited liability company. So usually probably the wife or some other friends would be a nominee. They will often have 1 share just to satisfy the minimum requirement. But that requirement has been gone. So we have now seen a lot of limited liability company with only 1 member and 1 director. But usually the company secretary will be another person, usually will be the accountant, but the shareholders and the director will be only 1 person. And that person, of course, would also be the sole signatory of the bank account maintained by that particular company. But it is very, very important to see that limited liability company incorporated in Hong Kong is a separate legal entity. So, compared to the sole proprietorship, when the business assets belongs to the person, to the proprietor, the business assets in a limited liability company belongs to the company itself. Instead, it is the shares that goes to the estate if that particular shareholder dies. What happens when the sole director and the sole shareholders of a limited liability company dies? Similar to the sole proprietorship situation, nobody is going to run the business. Nobody is going to do all the decision making. But then, as I said, the shares falls into the deceased estate. The distribution will depend on the sole shareholders' will or the intestacy rules. What is very important here compared to the sole proprietorship is that if that particular person passed away, after the probate is obtained, it does not mean that the business automatically survives. There's one more step. That is to transfer the shares from the executor or the administrator to the beneficiaries. And this particular process requires some proper appointment of director, because the directorship does not, is an appointment. It's not an asset. It cannot be transferred by the will. So there has to be proper transfer of shares, appointment of directors, and then changing the bank signature at the bank account of the company in order to have access to the bank account. Just by saying that, you would appreciate how complicated it is, especially when we are talking about someone who does not have a will. I give you a very good example. Maybe this one, case scenario. Again, I will make it particularly simple, very similar to the same proprietorship situation. Tom is the sole director and the shareholders of his limited liability company. He employs 2 staff to help him run the business. The business has 2 million accounts and receivables and 1 million book debts, something like that. Same old, same old, same old. What will happen to his business if he dies suddenly? Question. These are the major questions that we often ask our client to think about when they have a business. Who has access to his company's bank account to pay the expenses and the salaries? Nobody. Nobody will have, so it's not one family who is affected. Also the 2 staff, who is probably also the breadwinner of the family. Where are they going to pay their wife, their children? Who can run the business for him? Nobody is making a decision for him. At the same time, because he passed away, he doesn't have an income anymore. Nobody has access to the company, right? Even if he has been drawing a salary for himself in order to maintain his wife and his family, young children. After he's passed away, nobody can do that for the wife and the children anymore. And who will recover the receivables for him? Again, this is the question that a lot of people will ask, especially when that person is controlling the company 100%. Think about it. Nowadays, most people have everything in the laptop. Just by having the good password to have access to his laptop in order to see the accounts, to see the invoices that he has been issuing, and the amount, the receipt that has been issuing, and to trace whatever that is going on with the company, requires a lot of hassles already. And we have been dealing with similar cases before, and I can assure you that it's a pain because nobody has access to it. Who settled the debts for him? Of course, the debt belongs to the company, actually. But if the debts are not properly settled, the company would be insolvent, and the creditors has ground to either take legal action against the company, or even to a more aggressive extent, petition for winding up. If the company is wounded by court before the probate is issued, the company, which is probably it could be the major assets in the family, will be lost. It would be a very substantial loss to the family, especially when a majority of is the company itself. Another issue that I want to say is the tax return. This is also coming from our experience. When there's only one director who is the director in the company, after he passed away, as I just said, nobody can become the director until the shareholders is changed, transferred from the deceased to anyone else. And that particular shareholders would then have to appoint himself as director. That process may take a few months, if not a year. So, the problem, you can see, if there's tax return that has to be filed, if there's any delay, the Indian Revenue Department would definitely issue demand, if not, and then penalty, and then a summons to require the director to go to court to admit that he had been late filing the tax return and then pay a fine. This is not something very nice. We don't want that to happen to the company. This is particularly the case when the estate is particularly complicated or when there's a dispute. I've recently come across a case when the deceased is the sole director and the sole shareholders of the company. He passed away. He did not make a will. At the same time, there are family members who launch a claim against the estate and prevent the probate or the letter of administration from being granted. He passed away in early 2014. Now it's 2015. And when he was still alive, he did not file the tax return for 2013. So now there are already 3 years that the tax return has not been filed. Nobody can sign the tax return because nobody can sign the audited report. And because of that, the IRD is already asking for tax return and then issuing the summons, asking for penalty. In order to address to that, in the course of the litigation, what we have to do is to appoint someone as the temporary administrator. We call it administrator pending suit. In order to assume the position, sign the necessary tax return, and keep the company from going. This itself is a major process that would incur a lot of costs, especially when the family members are not in harmony and they object to the appointment of this administrator, either on the ground of necessity or the nomination. Even one party want to appoint KPMG, one party want to appoint EY, and one party want to appoint other firm. Everyone wants to get a piece of it. So, these all complications can be avoided. How? Appoint a reserve director. A reserve director does not assume the position until the only director passed away. That particular director can ask the bank to change the mandate in order to have access to the bank account and immediately get the company going. The director also can conduct directors' meeting and then, if necessary, launch other resolutions in order to transfer the shares to other people or to allot new shares, subject to the terms of the memorandum and articles of association. That can keep the company going. And then, also, of course, make a will, just to avoid what we've just said in relation to the potential dispute. A very good example for Tom is that if he did not make a will, according to the intestacy rules, assuming that he's a Hong Kong person, his wife will take the first $500,000, and then his estate will be divided to his wife, 50%, and the remaining 50% to the two young children of the family, of Tom. That means that the children will become 25% of the shareholdings of the company, which is not desirable. Not to mention that the probate process will be particularly complicated for Tom's wife. That would delay the probate process as well. Make a will. Leave everything to Tom's wife so that she can become the sole shareholders of the company. So then she can appoint herself as the sole director, or she can also consider, if the staff is interested, appoint them as the director of the company, and then negotiate with the staff as to whether they will be interested in acquiring the company. because they have been following with the operation. They have been knowing the operation inside out. If with a good price, they may be interested in acquiring the business. And then the wife, instead of getting a business that she had no idea about and doesn't know how to run, the staff will run for her or just buy it out from her, at least inherit the actual financial benefits of the company. Of course, also allow people to have access to the details of the account receivables, liabilities, future expenses, etc., just to keep the company moving. Avoid a lot of hassle in locating this kind of information. So, and of course, what we just said earlier in relation to the keyman insurance also applies. But there's one thing that I forgot to mention about the keyman insurance is that it is actually just an insurance policy. But to take it out, the premium should be regarded as the employee benefit of the sole director. And it becomes remuneration that is tax deductible. So at the end, it helps. There's a tax benefit of it as well. So there's a benefit for it that every sole business owner should think about. And also, of course, these are the highlights for key points for the sole business owner in how to consider what would happen, what is important when something happened to them. Distribution of the shares, continued operation, eventual sale, in order to ensure provision for the family and the continuation of the business. This is a summary. I hope that you will find this summary helpful when you are dealing with your clients with a situation like that. So, what I have been talking about in relation to the one-man band, we call it, this is already complicated enough. What if there is a partnership? Partnership requires at least two people who is running the business together. A lot of time, these two partners are registering with a business registration. They are not, in this scenario, they are not incorporating a company to run their business. No particular form. And this is also common when we talk about small business. For example, a small company or small shops selling candies, selling necessities, or whatever. A lot of people may want to streamline their business. They just don't want to have a company. They don't want to file the return, the annual return and things like that. But they don't mind bearing the business liabilities themselves. Similar situation. Instead of John running the business alone, now he's running with Mary. But then it is very common when two partners are running the business together, one is responsible for one part of it and the other responsible for another part. And in this particular situation, John is the outside one who's going around running the business, acquiring clients, making deals with the clients. And Mary stays in the company, looking after the internal side, administration side, paying the salaries, paying the utilities, making sure that things are running well. And again, this business has 2 million accounts receivables and 1 million book debts. Other situations are the same. The only difference is having Mary to help him running the business. So, the problem, this time, because there are two partners, what if John passed away, what will happen to his business? I suppose at least Mary can run it, right? It shouldn't be a problem. But let's see. First question, if he has been running the business, would Mary have all the information in relation to the ongoing business? What leads that he has been going out, following up in terms of new business, and whether there's any promises that he has made for the company, there could be a lot of surprises when one person is running a company without the partners telling them what's going on. And as you can imagine, these surprises can be good surprise, and could be nasty surprise. At the end, we do not want the business to decline because the only person who's been going around looking for new business has already gone. What can Mary do? And then also, when Tom, this particular person, passed away, he cannot draw a salary anymore and provide for the family. Again, what would the family be relying on? He's the breadwinner of the family. So, let's see if we have solutions to it, as we always do. Partnership agreement. So, this is the part. To have a partnership agreement between the two partners, setting out the scenario when one partner passed away, the other surviving partners can acquire the interest from the deceased partners. So, of course, when they're talking about this kind of nasty scenario, they would have to talk about where do you keep all this information, how to assess the value of the company. So, how to assess and ascertain the price that the surviving partner can buy out from the deceased partner's family. That would be fair, at least, because the widow who doesn't know anything about the business at least would know that she would be provided for and benefit from the business when he passed away. Think about it. We have dealt with a situation before when the deceased partner passed away. The surviving widow was approached by the surviving partners and say, actually the business has always been running at a loss, and your husband is supposed to contribute to the losses suffered by the businesses. And in that respect, we have to sell his home, sell his car, sell his jewelry, sell everything in order to pay back to the business. If the widow is not very, we don't want to say very smart, but the business acute, she would probably believe in him because the surviving partner is often a very close friend. Why wouldn't she believe in someone that her deceased husband has been dealing with and have been treated as a good friend? But she would never know whether he's telling the truth, because she never knows what had been happening with the business. She only knows that her husband used to be providing for the family, keep having money coming in, even better, probably a lot of money coming in for her and for the family. She has been spending a lot without knowing that probably the business is not as good as she thinks. It could be true, it could be not. To have the partnership agreement, at least, that would also provide the widow a recourse. The best thing she could do, go to a lawyer. Let the lawyer help her on what sort of rights she would have in relation to the business of the company in order to ascertain whether the surviving partner is actually telling the truth. So, if Tom dies without a will and a partnership agreement, with a will and the partnership agreement, that is the benefit. His family will be able to benefit of his share of the business. Mary will be able to run the business as usual, the surviving partner. So, question. If the surviving partner is saying that, I don't have money, I don't know how to buy you out, I cannot buy you out, what can I do? Again, what we just said, human insurance. That human insurance would be then that the surviving partner would be the beneficiary. The surviving partner would then immediately have the fund to buy out the deceased partner's shares she can continue running the business. The widow would be able to enjoy the fruit of the business from the deceased husband. It's a win-win situation. But a lot of people wouldn't think about it. And if you don't think about it, trouble ensues. So, what we've just discussed is the partnership arrangement. As we have just said, again, partnership, sole proprietorship, liabilities goes with the sole proprietor or the partners. So it's not desirable. Most people do take this advice and set up a limited liability company instead. So, in this scenario, we have shareholders instead of partners. And they are equal, although we didn't say that they are very clear here, but let's assume that it's 50-50. And the situation is very similar. The only difference is a limited liability company that holds the account of the business. Again, if the business if the deceased shareholders passed away, how to protect his family, how to protect his legacy. Same question. As we just said earlier, the legacy that is leaving behind is not the business, it's the shares of the business. And when it's the shares of the business, the transfer of the shares becomes critical, because that is the estate. We want to ensure, we want to achieve the goal that we have set earlier. Continue operating the business with minimal disruption, ensuring the family can inherit the benefits. We need to consider is the right of the surviving shareholders, because effectively, after the grant is issued, the shares become the beneficiaries. The beneficiaries, theoretically, has the right to decide how to dispose of the shares. What if she decides to sell it to the competitor? Can Mary stop her from doing that? Let's see. Partnership agreement is not applicable here, but of course, there's also something called shareholders agreement. Shareholder agreement is not something that we see very commonly used among shareholders, mostly because when two people come together and set up a business, especially when we're talking about a small business, a lot of times they're friends. They have a very high level of trust and confidence towards each other. But what they do not say among the relationship is what happened if one party suddenly dropped out. And this is a very sad situation because nobody knows how to deal with this kind of situation. So a shareholders agreement is actually a very helpful tool in dealing with situation when one shareholder passed away. The surviving shareholders will have the right to first refusal to buy the shares of the deceased shareholder. That means that if the surviving shareholders is willing to buy out from the estate of the deceased shareholders, she will become the sole shareholders of that company. She will not have to worry about sharing the business with anyone that she doesn't want to share. So, again, similar situation. The price of the shares of the deceased shareholders can be determined with reference to the audited account of the LLC. Audited account often describe how much turnover, how much business assets, how much liabilities, and the reference can be made to the business assets or the net profits of the company with a multiplier, for example. Then it's very easy to ascertain the amount that the surviving shareholders can buy from the deceased shareholders' estate. In order to ensure that, again, the surviving shareholders have the financial means to buy out the shares of the deceased shareholders, take out a key man insurance. Make sure that the surviving shareholders have the financial means. From here, you can see that actually we are not talking about rocket science. We are not talking about something very complicated. We're just talking about some useful tools that can very effectively cover the scenario when something happened to the very important person in a particular business. So, this is a summary of what we have discussed so far. Let's see. The company's information is accessible by the family or the surviving shareholders of our partners. Make sure that the family is covered against any financial strain due to the demise. And for business with multiple owners, make sure that the business can continue with minimal disruption, and the interests of the business partners and own family are equally covered. I think I'm supposed to end at 1:25. Now it's 1:25. I've been very good at keeping my time, luckily. But then, of course, the question and answer, please feel free to ask us.
Do we have any questions? Well, I have a question.
Okay.
Yes, at what stage do you normally find people coming to you for this type of planning, and how important is it to plan for this at the inception of a business, even if you're not sure how successful or how long that company will continue to grow?
You want to answer it, or I will? Okay, I will answer it. From my experience, most people come to us for estate advice when they started a family or they start having children. It doesn't matter what stage their business are in. And we always tell them that estate planning should start as early as possible, because first of all, you don't know when you're going to die. I'm so sorry, touch wood. We all may die one day. We have seen so many sudden deaths already. And the second thing is that if you have already started a business with your business partner, and all along you have been running that business with him or her upon trust and confidence, you never talk about shareholders' agreement. When the business has come to a certain size, it has become an elephant in the room. How do we going to discuss this? Because if we're just talking about succession planning, shareholders' agreement, there would be other things that ensue, because the disease, the demise, the death of the shareholder is not the only situation which a shareholders' agreement will not cover. There are other situations that you want to cover in terms of the shareholders' agreement as well. For example, what if they start into an argument, how to have an exit strategy, and in terms of daily routine, who can have decision, and who can have decision of how to bring in a new business partner, something like that. So, my advice would be, as early as possible. Shareholders' agreement, partnership agreement should be made at the inception of the business, but it's never too late.
Okay.
Yes.
Yes, it's easy to understand that and to explain to clients. But usually these entrepreneurs, they are starting a business with a low budget, they control the cost. So the question is, how much does it cost to put a shareholder agreement? In general, what is the range of budget you can see?
It is indeed a very difficult question. The reason is that every situation is different. When we're talking about a shareholders' agreement or a partnership agreement, we need to look at how extensive, how long it is, what sort of situation to cover. Of course, there are a lot of templates that you can even download from the internet that can cover major situations. But of course, we are not advising that, because most of the time, when people download a piece of documents and just sign it, that means that they've never read the contents therein. They don't even understand what it is. So it really depends on the nature of the business, how they operate, each role in the business, and how extensive they want to have. It is something that is worth considering, but I cannot really give a figure. I can only advise on what is the current budget and how far we can achieve for them. I hope I answered the question. In a way, yes.
Okay, I think I'm the only business owner here.
Actually, you're not. I'm also a business owner.
Okay, you are the business owner?
I'm also a business owner.
Okay.
I have a business registration. Unfortunately, I cannot incorporate a company because my professional rules do not allow me to do that.
Okay. So basically, I mean, I have multiple companies, and some of the companies are, I won't say sole proprietors, LLC, because it's sole ownership.
Understand.
And then I have partnerships as well.
Yes.
So, I mean, thank you very much. I think I learned something today.
Very good. Thank you.
I will go up and get what do you call a key man insurance, right?
Yes, key man insurance.
So
Talk to your broker.
okay. Now, for the key man insurance, you buy if it's a partnership or multiple shareholders.
Yes.
You buy it for the company. Is that correct?
Yes. The policy owner will often be the company, and the person insured would be the key man. And the beneficiary would either be, usually would be the surviving shareholders.
Okay.
So they would be split, usually used as a company expense. That would be deducted from the company profits. But then it would be a part of the remuneration of the particular key man that may or may not be taxable in their own respective income. This is something that, again, a tax advisor would help.
Okay. Now, another question, I think it's a little more difficult because I've been looking at it.
Yes.
And because I'm in a particular industry, which is aviation.
Yes.
And one part of the business is very difficult. And general aviation is just the beginning here in mainland China.
Yes.
And I was the first woman to start the business.
Yes.
So far, I have not been able to find a successor, and I have no children. So what do you do in a situation like this? Because I've been looking at funds, and I've been looking at, but funds, they have only cash. They can't run the business.
Right.
So how can my business survive? I mean, the employees so far I'm not able to, run the company. No, I have not found anybody who can replace me.
Oh, this is a fair. Well, first of all, this is a very practical question. In terms of business succession, finding your successor, there's no strict solution, and it is not something that a particular legal document can help. Especially in terms of a business that is so specialized and so niche. The talent out there would not be a lot. And even if there's a talent out there, there are a lot of other considerations. For example, would you be concerned that one day he would just jump up and start up his own company and then steal all your clients away, for example? This is something also very practical that we do not have a straight answer to it. But then what we can only say from our clients' experience is that succession planning is not one-step process. It takes years. You have to work with that particular successor, give them time, let them grow, and see whether it has the strength to take on and take up your business in the long term. And if not, perhaps the only solution for you is to find a buyer so that the buyers can find someone to take your place. But then, at least, you would have the benefit of selling the company with the proceeds. And then you can consider what you are going to do with your estate. Whether you want to benefit your relatives, you want to benefit your godson, godchildren, or even a charity. Something that is requiring a constant consideration, and you may change your mind 10 times in the next 10 years. Something that is that requires a very personal talk. Okay.
But can you say organize a trust so that you can appoint certain employees in the organization to co-run the business and have a law firm or auditor's firm to check the
Of course,
because the business is very profitable. And so, I mean, they may have shares to the company, and then whatever can go to charity. Things like this.
This is definitely doable. But the mechanism itself is fine. Setting up a trust, injecting your company in, with you running the business until one day when you can't run the business anymore. But the most important thing is that after you become unable or you do not want to run your business, who is going to continue running the business? Again, finding your successor is very important.
But, I mean, I don't think of dying of natural death, but something can happen.
Exactly,
right?
exactly,
So
exactly.
If I drop dead tomorrow,
I understand, and this is something that can be put in place, and this is also what we encourage our client to do with the family with family trust, projecting the company into the family trust, so that in future, whatever happened to you, you will not have to worry about your business being eroded. Yeah. Okay.
Thank you.
Thank you.
So thank you to Alfred and Scherzade. We have some gifts for you.
Thank you very much for having us, especially on the day after we are all stuffed with turkey.
Yes.
If there's, I believe that I've given you my card. If there's anything that either myself or Scherzade can help, please do let us know, okay? Thank you very much.